Good evening. The Honorable Judges of the Supreme Court, Honorable Judges of the High Court, both sitting and retired, who are with us in the audience today, members of the Nariman family, Nina, distinguished guests, esteemed colleagues, and my dear friends. It is a privilege to welcome all of you to this event that is dedicated to the memory of one of India's most extraordinary legal minds, Fali Nariman. Known for his unparalleled expertise in constitutional law, Mr. Nariman was a legal luminary, a senior advocate of the Supreme Court since 1971, President of the Bar Association of India, and a recipient of the Padma Vibhushan and the Gruber Prize for Justice. His contributions to our legal system and public life have left an indelible mark on the fabric of our nation. Mr. Nariman stood as a global beacon of justice, representing India in international councils, always upholding the highest constitutional values. His courage and conviction were exemplified by his resignation from the post of the Additional Solicitor General during the emergency in 1975, an act that underscored his commitment to the rule of law. His work in landmark cases, which are far too many to name, have profoundly shaped the Indian legal landscape. These cases were more than just legal battles. They were defining moments in our nation's journey where justice and constitutional integrity were upheld, often against immense challenges. As Mr. Nariman himself once said, the ultimate measure of a man is not where he stands in moments of comfort and convenience, but where he stands at times of challenge and controversy. These words reflect the essence of his life, a life that was spent standing firmly on the side of justice, even in the most trying of circumstances. Today, we gather not to remember his extraordinary achievements, but to draw inspiration from his unwavering integrity, intellectual brilliance, and deep moral compass. Mr. Nariman showed us what it means to live a life of purpose and principle, and his legacy continues to guide and inspire us. May I now invite the President of the Bombay Bar Association, Mr. Nitin Thakkar, to address the gathering. Mr. Thakkar.
The Honorable Mr. Justice Bhushan Gavai, Judge Supreme Court of India, the Honorable Mr. Justice Sundaresh, the Honorable Mr. Justice Ujjwal Bhuyan, the Honorable Mr. Justice Prasanna Varale, Honorable Mr. Justice Atul Chandurkar, Senior Most Judge of the Bombay High Court, who is presiding today, all the esteemed judges of this Honorable Court, past and present, and all the judges who have joined online from Nagpur, Aurangabad and Goa, former judges of the Honorable Supreme Court and this Honorable Court, former Chief Justices of various High Court, my friend Dr. Birendra Saraf, Advocate General of Maharashtra, the President of Advocate Association of Western India, the Chairman of Bar Council of Maharashtra and Goa, Nina, Nariman and other family members, senior advocates and other members of the bar, invitees, Registrar General and other officers, ladies and gentlemen. A very good evening to all. What a coincidence today. It is a trinity. A day to pay tribute to Dr. Babasaheb Ambedkar. He is Mahaparivartan Day, an architect of our constitution. A lecture in memory of Fali Nariman, a staunch defender of our constitution and constitutional expert, Justice Bhushan Gavai. The speaker today representing the strongest pillar of democracy, the judiciary. A very, very warm welcome to the Honorable Mr. Justice Bhushan Gavai. Bombay Bar Association and Advocates Association of Western India are extremely grateful to you for having agreed to come here today to deliver the inaugural Fali Nariman lecture. Beginning of this year, while addressing a condolence meeting for Mr. Fali Nariman, we had declared that we will hold a memorial lecture in memory of Fali Nariman a tribute to a giant. He has been described as more than a jurist, a crusader of justice, a defender of constitutional values, and an uncompromised voice of reason. He has been also referred to as an ethical giant, a conscious keeper of judicial institutions, a doyen of a bar, a towering figure of wisdom and intellect. He was an epitome of what righteousness stood for. Above all, he was a great human being. Mr. Nariman was an institution by itself. He was our esteemed member. He started his practice in Bombay High Court, and all of us who were fortunate enough to appear with him or against him, or those who had an opportunity to observe him arguing before a court, would come out with the feeling that I have learned something today in terms of courtcraft, art of advocacy, presentation backed by research. From his articles published, his interviews, and of course his arguments in court, he has taught countless generations of lawyers. We would be failing in our duty if we fail to keep his memory alive and do not provide future generations of lawyers and judges to know who Fali Nariman was and the principles and values for which he stood and the causes which he espoused. His contributions to legal landscape is tremendous, and this memorial lecture series is our humble attempt to pay tribute to him. And to deliver this inaugural lecture, who better person than Justice Bhushan Gavai? He does not require any introduction to this august audience. He has been member of both the associations. Dr. Babasaheb Ambedkar is idol of Justice Gavai, a fearless judge who is upholding constitutional values, defending fundamental rights of citizens, be it in what is known as bulldozer matters or matter of establishing educational institutions, protecting rights of marginalized section of society, protecting environment. The list would be endless. As Fali Nariman would have said, there is someone who will jealously guard rights of citizens and uphold rule of law. And Justice Gavai is a very, very humble person. And I would like to share my recent conversation with him. When I asked him what arrangements the association should make for his travel, etc., he immediately told me in his words, whenever I travel for my associations, I travel at my own expense. He has done this time also. Sir, we are extremely grateful to you. It is very noble of you, and both the associations are very grateful to you for coming today and agreeing to deliver the inaugural Fali Nariman Memorial Lecture. Sir, thank you very much. I welcome all of you here, and I will not take any more time, and I thank you very much.
Before we start the speech for the day, there are a couple of felicitations which are required to be made. I would like to call upon the President of the Advocates Association of Western India to present a small memento to Justice Gavai. Okay. Kainath, be ready. 1-1, 1-1. Come out. Yes. Now I'd like to ask our President Nitin Thakkar of the Bombay Bar Association to present a small memento to Justice Gavai. Next, I'd like to ask the Vice President of Advocates Association, Mr. Kolekar, to present a memento to Justice Sundaresh. I'd like to ask our committee member to also present something to Justice Sundaresh. Anita? Next, I'd like to call upon the Secretary of the Advocates Association, Mr. Suresh Sabrad, to present a shawl to Justice Bhushan. And our committee member Kainaz to also present a small memento to Justice Bhushan. Next, I'd like to ask the Treasurer of Advocates Association, Mr. Rakesh Bhatkar, to present a shawl to Justice Varale. Anita Castellino, committee member of the Bombay Bar, to present a memento to Justice Varale. Next, the Joint Secretary Vikram Valavalkar to present a shawl to Justice Chandurkar. And the President, Mr. Thakkar, to give a small memento to Justice Chandurkar. May I now request the Honorable Mr. Justice Chandurkar, who is presiding over today's function, to address the gathering. Justice Chandurkar.
Honorable Shri Justice Bhushan R. Gavai, Judge Supreme Court of India, Honorable Justice Sundaresh, Honorable Justice Sujal Bhuyan, Honorable Justice Prasanna Varare, all judges of the Supreme Court, esteemed former judges of this court, all my colleagues at the bench, Shri Nitin Thakkar, President of the Bombay Bar Association, Mr. Redekar, President of the Advocates Association of Western India, Shri Saraf, the Advocate General, Shri Sangram Desai, Chairman of the Bar Council of Maharashtra, senior advocates, friends, ladies and gentlemen. Good evening to all of you. At the outset, I may state that our Honorable Chief Justice, Shri D.K. Upadhyay, was to preside over today's memorial lecture. However, for pressing reasons, he is unable to remain present today amongst us. He has conveyed his best wishes for today's memorial lecture, as well as his warm regards to all present. It is with great pleasure and honor that I have this opportunity to address the esteemed gathering at the inaugural Fali Nariman Memorial Lecture at the Grand Lawns of the High Court. This memorial lecture, in dedication to one of the most exceptional and respected lawyers of the country, Padma Vibhushan, late Fali Nariman, seeks to explore his life, work, and legacy. It is indeed a welcome step, and hence a special thanks to the Bombay Bar Association as well as the Advocates Association of Western India for the hard work and efforts in organizing this lecture for our enlightenment and mutual benefit. This memorial lecture can certainly be recognized as a sincere effort to celebrate and delve into the remarkable contributions of late Fali Nariman to the field of law and justice. This event aims at creating an engaging platform where all stakeholders can reflect on their profound impact, discuss the enduring relevance of their work, and inspire future generations of legal minds. Any event of this type, and especially in the honor of a great stalwart and personality who has been a beacon of legal wisdom, integrity, and jurisprudence, whose legacy continues to shape our legal landscape, is of utmost significance. It would fulfill the ideals and principles to the fullest possible extent. It provides us an opportunity to honor the noble soul and the unparalleled achievements from the immense contributions to landmark judgments to transformative legal reforms, and also to learn from his exemplary career. Late Fali Nariman held a strong belief that senior lawyers are responsible for nurturing and guiding the next generation of legal professionals. Mentoring was viewed by him as a crucial aspect of his role, and he had indeed dedicated himself to shaping the future of legal fraternity. With his sheer commitment and numerous interactions, he has inspired and guided many of the aspiring lawyers with his wisdom and experience. The theme of the memorial lecture, Fali Nariman's role in shaping constitutional jurisprudence, is apt and quite interesting considering his devotion to the Constitution during his entire lifetime. There would hardly be anyone who does not recognize the enriching and productive role of Fali Nariman in shaping our constitutional jurisprudence. There have been numerous cases in which he had argued to the logical conclusions and won over the hearts and minds of both the bench and the bar. Be it the decisions in I.C. Golaknath, Keshavanand Bharati, second and third judges case, the NJAC, TMFI Foundation, or the Kaveri water dispute. The list is long. He has been a part of almost all landmark and path-breaking cases shaping constitutional jurisprudence during his lifetime. He was a true secularist and a socialist, an intellectual far above many legal luminaries, and believed in the core values of Constitution and stood for them throughout his life. He was a towering figure of intellect and wisdom. He was indeed a proponent of constitutional values. Today it is our privilege to have in our midst Honorable Shri Justice Bhushan Gavai, Judge Supreme Court of India, as the eminent speaker for this inaugural Fali Nariman Memorial Lecture. Constitutional jurisprudence is a subject that is very close to the heart of today's distinguished guest. All of us are eagerly awaiting to hear it from His Lordship, for being benefited with the pearls of his wisdom that he would be showering upon all of us with his insights and experiences related to the great jurist and lawyer. For the record, I may only state that my lord was part of the bench that decided the celebrated case of Nusli Wadia versus Ivory Properties, wherein late Shri Fali Nariman had appeared as regards the scope of Section 9A and Order 14 of the Code of Civil Procedure. I hope and trust that this memorial lecture will be an enlightening and inspiring experience for all concerned in the future. Thank you.
Thank you, Justice Chandurkar. And now for the lecture that we've all been waiting for on the role of Mr. Nariman in shaping our constitutional jurisprudence May I now request the Honorable Mr. Justice Gavai to come and deliver the lecture.
My esteemed colleagues from the Supreme Court, Justice Sundaresh, Justice Ujjal Bhuyan, Justice Prasanna Varade, the senior most judge of the Bombay High Court and the president of today's function, Justice Atul Chandurkar, my colleagues, brothers and sister colleagues from the Bombay High Court, including the past colleagues, Shri Nitin Bhai Thakkar, the president of the Bombay Bar Association, Shri Prashant Redekar, the president of the Western India Advocates Association, Shri Sangram Desai, the chairman of the Bar Council of Maharashtra and Goa, Shri Virendra Saraf, the learned Advocate General for State of Maharashtra, the former Advocate Generals, my friends Darais Kambata, Shri Hari Ane and Ashutosh Kumbhakoni, the senior lawyers present here in large numbers, all of whom I know personally, and the reference would not be permissible, so I only in a representative capacity only mention Mr. Avinash Rana Kaka, the members of my own bar associations, Bombay Bar Association and the Western India Advocates Association. I think I must be the only privileged one in the Supreme Court who is member of both the Bombay Bar Association and the Western India Advocates Association. At the outset, I express my gratitude to Nitin Bhai and Prashant Redekar for giving me an opportunity for this homecoming. It's always a pleasure for me to come back to my own High Court and to my own bar. And for a moment like this, it's always been a great pleasure. It is both an honor and a privilege to stand before this august gathering as we gather here to pay tribute to one of the legends in the history of legal profession, late Justice Fali Nariman. I forgot to mention the family members of Mr. Nariman. Nina is also there. It's a great coincidence that today we also pay homage to Dr. Babasaheb B.R. Ambedkar on his death anniversary, who is known as the chief architect of the Indian Constitution. Dr. Ambedkar's visionary leadership and understanding of justice laid the foundation for a democratic India, ensuring that the principles of equality, liberty, justice and fraternity were enshrined in our Constitution. In a similar vein, Mr. Nariman, through his exemplary contribution to the legal profession and his steadfast commitment to justice, expanded and deepened the values of the Constitution. I had a twin connections with Mr. Nariman. My father had a close relationship with Mr. Nariman. Both of them shared a bond during their tenure as members of the Rajya Sabha in the early years of this 21st century. As a junior judge in the Supreme Court, I had an occasion to share the bench with his illustrious son, Rohington. I had an opportunity to sit with him for almost 9 months, and I must say that I could learn a lot from him on the bench. He was kind enough to give judgments to me on various topics which were totally unknown to me as a judge of the High Court. During my practice days, I had also an occasion to assist Mr. Nariman in 2-3 matters. Mr. Shivaji Yadav, who is present with me, was also with us in those matters. His in-depth knowledge of law, dedication and devotion to to the profession. His industrious, courageous, and fearless approach always inspired me. I am therefore extremely grateful to the Bombay Bar Association and the Advocates Association of Western India for giving me the privilege of delivering the first Fali Nariman Memorial Lecture to cherish the memory of one of the legends in the Indian legal history. Mr. Nariman was more than just an eminent lawyer. He was a custodian of constitutional values, a defender of justice, and a relentless advocate for the rule of law. His deep knowledge, sharp intellect, and unwavering integrity earned him the admiration and respect of countless legal minds, both in India and also beyond the seas. Let me outline how I plan to proceed this evening. I'll begin by setting the context for reflecting on the life and enduring legacy of Mr. Nariman. Following this, I will delve into his instrumental role in shaping constitutional jurisprudence by examining 3 sets of landmark cases he argued relating to the basic structure, independence of judiciary, and fundamental rights, including the minority rights. I'll be referring to only selected cases because it is not possible in a short period of time to reflect on Mr. Nariman's career span over more than 7 decades. Next, I will highlight his unwavering commitment to constitutional values beyond the courtrooms. Finally, I will reflect on how his invaluable contributions to educating the public about the Constitution and its principles. We must begin reflecting on the life and legacy of Mr. Nariman by understanding the role that the courts and the lawyers play in the constitutional democracy. Courts have an indispensable role in shaping the fabric of society. Much has been written and discussed about judiciary's functions in conceptualizing new legal principles, fostering constitutional values, and acting as a vehicle for social transformation. Scholarly discourse often explores the court's responsibilities and limitations. Their exercise of judicial review in maintaining democratic accountability, their position as guardians of the Constitution, and their proactive intervention of safeguarding the fundamental rights. However, what courts can and cannot achieve is not solely the product of judicial deliberations. The trajectory of court decisions is significantly influenced by the contribution of lawyers, who are vital stakeholders in the judicial process. Lawyers play a crucial role in shaping constitutional discourse. While judges hold the authority to interpret the Constitution, it is a lawyer who craft and present the interpretative frameworks that guide judicial reasoning. Lawyers contribute to society not merely by interpreting the law, but by ensuring that justice is accessible to all segments of society, particularly the poor and the marginalized. Public-spirited lawyering has been instrumental in broadening access to justice and bringing constitutional ideals closer to the people. Beyond their formal role in the courtroom, lawyers serve as catalysts for social transformation. Through strategic litigation, they influence the public policy and draw attention to pressing social issues. The life and legacy of late Mr. Nariman provide a lens to understand the larger role of lawyers in a constitutional democracy. Mr. Nariman was a part of a pioneering generation of lawyers who began their practice after the Constitution of India came into force. This generation faced a dual and exceptional challenging task that set them apart in history. Firstly, they were tasked with building precedents rather than relying on them. When the Constitution came into effect, the jurisprudence surrounding it was nascent. The Supreme Court of India had to establish a body of authoritative rulings to guide practitioners and the judiciary. Secondly, this generation had the responsibility of interpreting and applying the law directly from the text of the Constitution. Their work demanded not only deep understanding of the constitutional language and principles, but also a visionary capacity to foresee how their interpretations would influence future legal and societal developments. This dual responsibility of laying down precedents and interpreting constitutional principles made their experience both unparalleled and invaluable. It positioned them as torchbearers, illuminating the path for future generations of lawyers and judges. Their contributions were instrumental in transforming the Constitution from a written document into a living, organic, dynamic framework of governance. Let us now see the early life of Mr. Nariman. He was born on 10th January 1929 in Rangoon, then part of the British India. He, along with his family, later came to India prior to independence. Nariman pursued his law from Government Law College, Mumbai, as he noted in his autobiography, before memories fade, and I quote, "I greatly enjoyed my 2 years and a little more at this century-old institution of legal learning, principally because of 3 part-time lecturers, all of whom were practicing lawyers at the Bombay Bar: Yashwant V. Chandrachud, Nani Palkiwala, and Jal Vimal Dalal. Mr. Nariman drew great inspiration from these 3 eminent lawyers of that time. A turning moment in his life occurred when he joined the Bombay Bar in November 1950, just a year after the adoption of the Constitution of India. After doing an apprenticeship for a year at Penne and Company, a leading solicitors firm in Mumbai, Mr. Nariman got referred to the chambers of Sri Jamshedji Kanga, which was considered to be the most prestigious chamber in Mumbai. For Mr. Nariman, this was the most important prop to his professional career. In his early days at the bar, Mr. Nariman and his peers would often spend time in courtrooms observing proceedings to understand the practice of law. Reflecting on those early days, Fali Nariman offers insight in his autobiography that remain highly relevant for young lawyers and judges of today. He said, and I quote, "I learnt quite early that when you join the bar, you must enter the law, as you do in the sanctum sanctorium of the magnificent Taj Mahal at Agra, with your head bowed because you know so little, and even when you grow up, even when you are at the top of the profession, you are always learning." Unquote. In the years that followed, Mr. Nariman's practice flourished in Mumbai. During his time at the bar in Mumbai, he was engaged in a case that was part of a bench of petitions famously known as Goloknath versus the state of Punjab. During that period, it was the first time that an 11-judge bench of the Supreme Court was constituted to hear a matter. However, as we know, that Goloknath was not an isolated decision. It was a part of series of landmark cases spanning 3 decades, from Shankar Prasad versus Union of India in 1950 to Minerva Mills versus Union of India in 1980. The common question related to judicial review over constitutional amendments enacted by Parliament and whether Parliament can alter any part of the Constitution. In Shankari Prasad, the Constitution First Amendment Act 1951, which had inserted Article 31B, was challenged before a constitution bench of 5 judges. The amendment provided that none of the acts and regulations specified in the 9th schedule, nor any of the provisions thereof, shall be deemed to be void, or even ever to have become void, on the ground that such act, regulation, or provisions is inconsistent with, or takes away or abridges any of the rights guaranteed by the Fundamental Rights Chapter. It was argued before the court that the said article prevented judicial review of various Jamindari abolition acts put in the 9th schedule. In an unanimous decision, the court dismissed the challenge on the ground that to make a law which contravenes the Constitution constitutionally valid is a matter of constitutional amendment, and as such it falls within the exclusive powers of the Parliament. Following the judgment in 1964, the Parliament passed the 17th Constitution Amendment, which inserted 34 state legislations in the 9th schedule. In effect, a challenge to these legislations passed by different state legislatures was being prevented. The challenge to this amendment was heard by this court in the case of Sanjay Singh versus the state of Rajasthan, again a 5-judge bench. Writing for the court, Chief Justice Gajendra Gadkar, again from this court, expressed full concurrence with the decision in Shankari Prasad. The court held that, and I quote, "It is legitimate to assume that the constitution makers know that Parliament should be competent to make amendments in fundamental rights so as to meet the challenges of the problems which may arise in the course of socio-economic progress and development of the country." Unquote. Accordingly, the validity of the amendment was upheld. However, the seeds of the dissent were sown in the very same judgment. Justice Hidayatullah and Justice Mudolkar, they penned down their minority views. Justice Hidayatullah said that he would require a stronger reasons than given in Shankari Prasad to hold that the powers of the Parliament to take away the fundamental rights were also permissible. Justice Mudolkar also expressed certain doubts, and the seeds of the basic structure doctrine which is evolved in Keshavanand Bharati could be found in the minority judgment of Justice Mudolkar. He said that whether the power to amend would also include the power to amend the basic features of the Constitution, and in view, it was not permissible. The contestation continued with the setting up of an 11-judge bench in Golaknath. Mr. Nariman had the privilege of appearing as a junior counsel in 1967 for a group of petitioners in Golaknath, assisting both senior counsel A.K. Sen and Nani Palkiwala. By a majority of 6-5, the court overruled the decision in Shankari Prasad and held that Parliament has no power from the date of the decision to amend any of the provisions of Part 3 of the Constitution so as to take away or abridge the fundamental rights. Chief Justice Subbarao said, and I quote, "If it is the duty of the Parliament to enforce the directive principles, it is equally its duty to enforce them without infringing the fundamental rights." However, the judgment was overturned after 6 years in the largest ever bench of 13 judges in the case of Keshavanand Bharati versus State of Kerala. At the time when Keshavanand Bharati was heard, Mr. Nariman was already the Additional Solicitor General of India, and since he had appeared as a counsel for the petitioners in Golaknath, he did not appear for the government in Keshavanand. In the judgment, the court by a narrow majority of 7-6 overturned Golaknath, while affirming that no part of the Constitution, including fundamental rights, was beyond the scope of amendment. The court established a crucial limitation. The basic features of the Constitution could never be abrogated, even through a constitutional amendment. The indication given by Justice Mudolkar in Sanjay Singh became the law of land by Keshavanand Bharati judgment. The doctrine of basic structure was cemented in Minerva Mills in 1980, in which Mr. Nariman appeared as a counsel for the petitioner. In this case, Article 31C was amended, which provided that no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges the fundamental rights guaranteed by Article 14, 19 or 21. And no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such a policy. Similarly, it was Article 368 was inserted to make a similar provision that no limitation whatever on the constituent power of the Parliament to amend by of addition, variation or repeal the provisions of this Constitution. The court declared that the amended Article 31C was void since it damaged the basic or the essential features of the Constitution by a total exclusion of judicial review. The court also unanimously ruled that the amendments to Article 368 is void since it removes all limitations on the power of Parliament to amend the Constitution and confers power upon it to amend the Constitution so as to damage or destroy its basic or essential features or the basic structure. In the words of Chief Justice Y.V. Chandrachud, and I quote, "The Indian Constitution is founded on the bedrock of the balance between Part 3 and Part 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution." Although Mr. Nariman was not involved in 3 of the 5 cases mentioned herein above, his role as a lawyer for the petitioners in Golaknath and Minerva Mills was crucial. Together with Nani Palkiwala, who served as a lead counsel, he contributed to the team that firmly entrenched the doctrine of basic structure in India's constitutional jurisprudence. This doctrine serves as a safeguard against majoritarian tyranny, ensuring the protection of the Constitution by preserving its core features. Throughout his illustrious career, Fali Nariman remained a staunch defender of the basic structure doctrine, arguing several cases that relied on this principle. Beyond his courtroom contributions, Mr. Nariman emerged as a public intellectual and a staunch defender of the doctrine. He articulated its significance in lectures, writings, and public debates, consistently underscoring its role as a shield against authoritarian tendencies and a protector of constitutional values. Even in his later years, he remained a vocal advocate for the basic structure doctrine, firmly believing in its necessity to preserve the spirit and integrity of the Constitution. Mr. Nariman was a staunch advocate for the independence of judiciary, and his contribution through his arguments in landmark cases such as the second judge's case, the third judge's case, and the NJSA judgment were instrumental in reinforcing this principle as a basic feature of the Indian Constitution. The question of who holds primacy in judicial appointments and its connection to judicial independence was first elaborated upon in the judgment of S.P. Gupta versus Union of India, delivered by the 7 learned judges. The court, interpreting the term consultation in Article 124(2) and 217(1) of the Constitution, held that the Union government retained the final authority to decide on judicial appointments or transfers after considering the opinions of the constitutional functionaries. In case of differing opinions among consultees, the government had the discretion to decide whose view was to accept. This interpretation effectively accorded greater primacy to the executive in judicial appointments, raising concerns about its impact on judicial independence. In Supreme Court of Advocate on Records Association versus Union of India, Mr. Nariman played a leading role as a senior counsel who opened the submissions for the petitioners, advocating for reconsideration of the S.P. Gupta decision. He enlightened the various constitutional provisions with his extensive scholarly knowledge. He argued that the meaning of the expression after consultation with must be determined in the constitutional context and conditions only by the true nature and object of such consultation. He emphasized that the framers of the Constitution had deliberately included provisions for consultation with judicial authorities, especially the Chief Justice of India, to ensure judicial appointments were insulated from the executive interference. According to him, the process of consultation had a binding character, reflecting the constitutional intention to preserve judicial independence by entrusting this sensitive task primarily to the judiciary itself. Mr. Nariman also emphasized that since the concept of judicial independence is inextricably linked or connected with appointments to judicial office, it is essential that the process of appointments to the Supreme Court and the High Courts should be finalized as per the opinion given by the judiciary. Other learned counsels reinforced the submissions of Mr. Nariman. the Supreme Court by a majority of 7-2 overruled the S.P. Gupta decision and held that the term consultation, Article 124 and 217, meant that the opinion of the Chief Justice of India, formed in consultation with senior judges, would have primacy in appointments, matters of appointments and transfers. This landmark judgment established the collegium system, which ensured judicial independence by significantly limiting executive influence in the process. In his concurring opinion, Justice Kuldeep Singh, who we lost in the last week, acknowledged the considerable force in the contentions of Mr. Nariman. The court agreed with Mr. Nariman's articulation that the link between consultation, the advice given as a result thereof, and the ultimate appointment of the person about whom there is a consultation is inextricable, making the entire process of appointment of judges under the consultation as an integrated one. The independence of judiciary was reiterated in presidential reference of 1998, famously called the third judge's case. 2 decades after collegium was first established, Parliament passed the Constitution Act 2014, which led to the creation of the National Judicial Appointment Commission. However, the validity of the amendment was challenged in the Supreme Court Advocate on Record Association versus the Union of India, popularly known as NJAC case. On behalf of the petitioners, Mr. Nariman argued that both the Constitution 99th Amendment Act and the NJC Act violated the basic structure of the Constitution, particularly the principle of judicial independence. He emphasized that since the Constitution's inception, the primacy of the Chief Justice of India, representing the collective wisdom of Collegium of Judges, had been central to judicial appointments. Citing the second and third judges' cases, Mr. Nariman highlighted that the Chief Justice of India was not merely an individual decision maker, but embodied the collective opinion of the judiciary. He contended that the 99th Amendment and the NJC Act undermined this principle by removing the judiciary's decisive role in appointments, thereby threatening its independence. He maintained that judicial independence could only be preserved if the judiciary's primacy in appointments was unimpeachable. When the respondents relied upon Mr. Nariman's criticism of the collegium in his own autobiography, he submitted a personal note indicating that he preferred a commission that gave dominance to the judiciary in the appointment process. He stated that the composition of the commission is the basic issue, and a commission with non-judge domination would be not viable in India. The Supreme Court in its judgment struck down the NJC Act and the 99th Constitutional Amendment as unconstitutional. It held that the NJC system was inconsistent with the independence of judiciary and the separation of powers, both of which form part of the Constitution's basic structure. Mr. Nariman's advocacy in these cases was instrumental in preserving the autonomy and independence of the judiciary in India. Fali Nariman also argued several cases which dealt with the fundamental rights of the citizens. In Air India versus Nargis Mirza, a challenge was made to the airline's guidelines according to which the services of the air hostesses would stand terminated on first pregnancy. Though Mr. Nariman was appearing for the Union of India as an Advocate General and for the Air India, he convinced the management to do away with this arbitrary guideline. Justice Krishna Iyer, in his inimitable style, recorded his appreciation in following words, and I quote, "Apart from being grossly unethical, smacks of a deep-rooted sense of utter selfishness at the cost of human values. Such a provision, therefore, is not only manifestly unreasonable and arbitrary, but contains the quality of unfairness and exhibits naked deposition and is therefore clearly violative of Article 14 of the Constitution. In fact, as a very fair and conscientious counsel, Mr. Nariman realized the inherent weakness and the apparent absurdity of the aforesaid impugned provisions, and in the course of his arguments, he stated that he has been able to persuade the management to amend the rules so as to delete the first pregnancy as a ground for termination of the service, and would see that the suitable amendments are made, unquote. Mr. Nariman provided a great assistance as amicus curiae to the Supreme Court in Vishaka versus State of Rajasthan, where the court laid down guidelines to prevent sexual harassment at workplaces. The judgment was a landmark, and it later led to the enactment of the Prevention of Sexual Harassment at the Workplace Act 2013. Mr. Nariman was also a steadfast advocate for secularism and the protection of minority rights enshrined in the Constitution. He championed the cause of children whose education and childhood were jeopardized on the basis of their faith. By representing minority educational institutions, he vigorously defended their rights, ensuring their constitutional protections were upheld. Mr. Nariman appeared for the appellants in Bijo Emmanuel versus State of Kerala. The three children appellants, Bijo, Binu Moul, and Biddu Emmanuel, were adherents to the Jehovah's Witnesses' faith. They were expelled from their school for not singing the national anthem while they stood respectively. They refrained from singing as their religious beliefs prohibited it, not due to any objection to the words or sentiments of the anthem, but to the act of the singing itself. The Supreme Court held that, and I quote, the expulsion of the three children from the school for the reason that because of their conscientiously held religious faith, they do not join the singing of the national anthem in the morning assembly, though they do stand up respectfully when the anthem is sung, is a violation of their fundamental rights to freedom of conscience and to freely profess, practice, and propagate the religion. It was held that the fundamental rights of the appellants under Article 19(1)(a) and 19 and 25(1) were infringed. The court directed the respondent authorities to readmit the children to the school, to permit them to pursue their studies without hindrance, and to facilitate the pursuit of their studies by giving them necessary facilities. The court emphasized India's constitutional commitment to tolerance, affirming that personal religious beliefs, even if unconventional, must be protected unless they disrupt public order, morality, or health. Fali Nariman was also involved in the 11-judge bench decision in TMA Foundation versus State of Karnataka, which dealt with the rights of minority educational institutions and the issue of the government's control and regulation over private unaided minority educational institutions, particularly in the context of admission. However, the precursor to the TMA judgment was Ahmedabad St. Xavier's College Society versus the State of Gujarat, where Mr. Nariman appeared as the Additional Solicitor General of India. In that case, a 9-judge bench dealt with the question whether the minorities based on religion or language have the right to establish and administer educational institutions for imparting general secular education within the meaning of Article 30 of the Constitution. The court held that with regard to, and I quote, affiliation, a minority institution must follow the statutory measures regarding educational standards and efficacy. The prescribed courses of study, courses of instruction, and the principles regarding qualification of teachers, educational qualifications for entry of students into education institutions. In the words of Chief Justice Ray, and I quote, these regulatory measures for affiliation are for uniformity, efficiency, and excellence in educational courses and do not violate any fundamental right of the minority institutions under Article 30. The decision in St. Xavier's College Society was considered in TMA Foundation. This time, Mr. Nariman appeared on behalf of one of the petitioners. Nariman argued that the matter in favor of upholding the minority rights under the Constitution. In TMA Pai, the court held that, and I quote, admission of students to unaided minority educational institutions cannot be regulated by the concerned state or university, except for providing the qualifications and minimum conditions of eligibility in the interest of academic standards. The court further held that the right under Article 31 implies that any grant that is given by the state to the minority institutions cannot have such conditions attached to it which will in any way dilute or abridge the rights of the minority institutions to establish and administer that institution. The court read Article 31 and 29(2) to hold that the state government can notify only limited seats for non-minority students to be admitted in an aided minority institutions. Mr. Nariman thus played a crucial role in shaping India's constitutional jurisprudence on minority rights, contributing significantly to the legal framework that upholds equality, cultural diversity, and the protection of minority communities. Dr. B.R. Ambedkar once famously remarked that the Constitution is not merely a lawyer's document, but a vehicle of life embodying the spirit of time. Fali Nariman exemplified this principle throughout his life and career. He embraced the Constitution not just as a legal framework, but as a living document that guided his personal values, professional ethics, and advocacy. Outside the courtroom, Fali Nariman remained steadfast in upholding these principles in his personal and professional endeavors. Let me give two instances where I think he lived up to the spirit of the Constitution. The first relates to Mr. Nariman's appointment as Additional Solicitor General of India in 1972 for a term of 3 years. He thoroughly enjoyed his role representing the Union of India in numerous significant cases before the Supreme Court and several high courts. In 1975, he was reappointed for another term with an understanding that he would be elevated as the Solicitor General. However, when the internal emergency was imposed in June 1975, Mr. Nariman chose to resign in protest. Reflecting on his decision, he remarked, looking back, I have no regrets from the time I joined in May 72 till I quit on 27 June 1975. Mr. Nariman criticized the Supreme Court's most controversial ruling during the emergency, ADM Jabalpur versus Shivakant Shukla. The case addressed the suspension of fundamental rights under the emergency, including Article 14, equality, Article 19, freedom of speech and movement, and 21 and 22, safeguards of personal liberty. The court upheld the suspension of these rights and ruled that those detained during the emergency could not challenge their detention through the writs of habeas corpus, effectively denying them the ability to seek judicial review of their unlawful detention. Mr. Nariman expressed his disapproval, referring to the decision as one of the most deplorable judgments in the history of the Supreme Court. By resigning from his position in protest against the emergency, which he believed was unjust and stripped citizens of their fundamental rights, Mr. Nariman upheld the values of the Constitution and embodied its true spirit. The second instance is during the hearing in the state of Karnataka through its Chief Secretary versus state of Tamil Nadu, which related to the water dispute between the two states. For over 30 years, Mr. Nariman had represented the state of Karnataka. In a 2016 order, the Supreme Court passed an interim order directing the state of Karnataka to release 6,000 cusecs of water to Tamil Nadu. However, the Karnataka Legislative Assembly passed a resolution stating that the state did not have sufficient water to comply with the Supreme Court's order. When the matter was next taken up for hearing after a few days, Mr. Nariman submitted 2 letters to the court requesting it to to take on record. The letters pertain to the communication between him and the state government on compliance of the court's order for releasing water to Tamil Nadu. During the hearing, while referring to the contents of his letter to the Chief Minister, Mr. Nariman had told the bench that he had unequivocally stated he would not argue for Karnataka till the orders of the Supreme Court were complied with. The bench acknowledged Mr. Nariman's stand, noting in the final judgment, and I quote, Mr. Nariman had courageously lived up to the highest tradition of the bar, and we have recorded our uninhibited appreciation for the same. No discussion of Fali Nariman's legacy would be complete without addressing his involvement in the Bhopal gas tragedy case. The catastrophic gas leak in Bhopal, caused by the negligence of Union Carbide Corporation, led to the deaths of thousands and left many more with permanent health issues. Mr. Nariman represented the company at all legal forums in India and spearheaded the settlement claim for compensating the victims. Mr. Nariman's decision to represent Union Carbide in the aftermath of the tragedy drew significant criticism from the media and legal community. Many questioned his choice to defend a corporation implicated in one of the history's worst industrial disasters. In response to an article harshly criticizing his role, Mr. Nariman argued that suggesting human rights lawyers should avoid representing those accused of violating rights was a limited view of legal ethics. He maintained that every party, regardless of their actions, deserves representation to ensure a fair trial. Though his involvement in the case remains a controversial chapter, it also reflects the ethical complexities of legal practice, where personal conscience and professional duty often collide. In his autobiography, Mr. Nariman addressed the controversy surrounding his role in the Bhopal gas tragedy case by reproducing critical articles and letters that questioned his decisions to represent Union Carbide. His decision to showcase those criticisms understands his willingness to engage with opposing viewpoints. Mr. Nariman, however, later in 2010 expressed regret over his involvement, stating that in hindsight, he certainly would not have accepted the civil liability case. Reflecting on the matter during a news show, Nariman remarked, and I quote, "If I had to live my life all over again as a lawyer, and the brief came to me with the knowledge of everything that unfolded later, I would not have taken the case." Unquote. After resigning from the post of Additional Solicitor General in 1975, Mr. Nariman had shifted to House Coast Enclave in New Delhi. He took his last breath in the same house. Mr. Nariman received the Padma Bhushan in January 1991, and in 2007 he was conferred with Padma Vibhushan. In the last 2.5 decades, Fali Nariman was shaping the public discourse through his role as a member of the Rajya Sabha appointed by the President during 1999 to 2005, writing books and articles, giving interviews on key issues, and mentoring the young members of the bar and the law students. He also appeared in landmark cases to which I already referred. Fali Nariman wrote his autobiography in 2010, where he shared that he was offered a judgeship of the High Court at the young age of 38. He could have gone on to become the Chief Justice of India with a long tenure as a judge, but for financial reasons, he refused. Nevertheless, he was guide to many of the lawyers and judges of the present generation. Mr. Nariman was a prominent voice in public discourse, unafraid to express his candid opinions. He openly voiced critical views. I was a part of the Article 370 judgment, which was consistently criticized by him. Whether or not one agrees with him, but such conversations are necessary for the development of law. Mr. Nariman's dedication to the values of the Constitution was such that even in his last date, he was occupied in writing a chapter titled Values of the Preamble for a book which the Supreme Court of India published to mark the 75th anniversary of its foundation. He submitted his chapter by email a couple of hours before he took his last breath. In the conclusion of the chapter, he reproduced an excerpt from the judgment of the Supreme Court in the electoral bonds case, and I quote, "The preamble to the Constitution describes India as a democratic republic, a democracy in which citizens are guaranteed political equality irrespective of caste and class, and where the value of every vote is equal. Democracy does not begin and end with elections. Democracy sustains because the elected are representative to the electors who hold them accountable for the actions and inactions. Would we remain a democracy if the elected do not heed to the hue and cry of the needy?" Unquote. In conclusion, I would like to say that through his extraordinary career, he exemplified the highest ideals. For those who pursue law today, his life serves as an enduring source of inspiration. Listening to the stories and studying the arguments of such distinguished counsel not only deepens our understanding of the profession, but also underscores the critical role of lawyers in upholding constitutional values and driving social change. I've already crossed my time limit. I once again thank Nitin Bhai, Prashant, and all the office bearers of the Bombay Bar Association and the WIA, and my all colleagues and my friends at the bar for giving me an opportunity to be with you this evening, and for bearing me for more than 45 minutes. Before I conclude, I'll only share an excerpt from his autobiography. And I quote, "We demean ourselves and our profession when we resolve to strike work and paralyze the working of courts, tribunals, and statutory authorities where public causes and cases demand our expertise, intercession, and assistance. We also discredit ourselves and our profession when we curry favor with those in authority and power and do not stand up and defend the rights of the citizens. Let me on this day, while we pay homage to one of the greatest legal luminaries that India has ever produced, resolve to cherish and make every endeavor to uphold the constitutional principles of liberty, justice, equality, and fraternity to which Fali Nariman dedicated his entire life. Thank you very much."
Thank you, Justice Gavai. It is my privilege to extend a heartfelt vote of thanks on behalf of the Bombay Bar Association and the Advocates Association of Western India as we conclude this enlightening session dedicated to the memory of Fali Nariman. Today, we've had the distinct honor of hearing from the Honorable Justice Gavai, who has shared profound insights into the role played by Mr. Nariman in shaping our constitutional jurisprudence, which has not only enriched our understanding of the law, but also inspired us to reflect on the ideals that Mr. Nariman stood for. The lecture has been a true testament to the values that Mr. Nariman exemplified throughout his remarkable career, a commitment to justice, courage in adversity, and an unwavering dedication to constitutional integrity. I would also like to express my sincere appreciation to the organizing committee, the members of both the associations, the volunteers who worked tirelessly to bring this event into fruition. I would also like to express my gratitude to the registrar, Mr. Bhagwat, the court keeper, Mr. Manoj Gaichar, the PWD department, Mr. Deshmukh, and everybody from the staff of the High Court who has assisted in this function. Events like these remind us of the enduring impact of the work of various luminaries on the legal profession and the judiciary in India. Finally, my heartfelt thanks to all of you here today for your presence and participation. Your support for this lecture reinforces our collective respect and admiration for one of India's most revered jurists. In my opening, I only welcomed Nina Nariman. I forgot to also welcome and thank his daughter Anaita, who is also present with us today. Thank you for attending this lecture. Let us carry forward the inspiration that we have drawn from Mr. Nariman's life and work as we strive for a legal system that upholds justice, fairness, and the rule of law. Thank you very much. This concludes today's function.